We are going to talk about legal challenges, counterterrorism, and human rights. Dr. Miriam Feinberg is a postdoc fellow in the Minerva Center for the Rule of Law under Extreme Conditions. She just now published a new book, so she deserves Mazal Tov. The book is about sovereignty in the age of global terrorism, the role of international organizations, and it was published last month with Brill. Her PhD is from the Institute for Advanced Legal Studies in London.
Thank you. Microphone's okay?
Yeah, I think it's okay.
Thank you. I have the difficult task of speaking last after a number of inspiring talks, and I hope I can briefly contribute to this discussion before everybody's had truly enough. As Professor Barzilai mentioned, my research focuses generally on counterterrorism and including measures adopted by international organizations to address the threat. And today I'd like to speak about European counterterrorism against ISIS and examine its relationship with the migrant crisis to Europe. And this is based on a paper I wrote on the obligation to cooperate against terrorism and the consequences this has on the distribution of responsibility between states for global security. But for the presentation today, I look at European measures against terrorism adopted on the basis of UN Security Council Resolution 2178 to deal with ISIS, and in particular measures on citizenship removal. And I'll examine the efficiency of these measures and place them in the broader context of the refugee crisis. And I'll look at the conflation of narratives that emerges between foreigners, terrorists, enemy citizens, infiltrators, and argue that this creates an us versus them discourse that encourages symbolic measures with wide-ranging consequences on human rights in the region. And this presentation mainly raises issues and questions as opposed to providing solution, and contributes to explaining how bad the situation is. Sorry. So as has been mentioned throughout the day, the refugee influx that Europe is witnessing is not actually a new phenomenon, and a number of non-European countries have faced a huge influx of refugees over the years. But the impact on Europe itself and the EU is more recent, and it coincides for these countries with the rise of ISIS around 2014, which gives rise to discussion on the link between the two phenomena. And this is the case especially because recent measures on terrorism concern the movement of suspected terrorists and the nationality of suspected terrorists, which does also concern issues raised by the refugee crisis. On a side note, European countries are also conducting airstrikes against ISIS in Iraq and Syria, the legality of which itself is controversial. And this also leads to confusion between the more traditional criminal law approach to terrorism and the use of the laws of war. And this is, I'm not going to look at this, but it does contribute to the confusion of legal regime to address crisis. So one of the bases for counterterrorism measures recently is this Resolution 2178, which was adopted in September 2014 by the Security Council to deal with the emerging threat of foreign terrorist fighters and ISIS more generally. And it had to be implemented by all UN member states, including European states. It's a long and complex instrument, and it imposes a number of binding obligations on states, including the request to adopt new criminal law, to limit terrorism financing, to adopt preventive measures to counter violent extremism, etc. But interestingly, the resolution also includes, for the first time for a counterterrorism resolution, in the operative paragraphs of the resolution itself, not just preamble, the requirement to abide by international human rights law. And this is significant because the resolution includes so many measures that directly address or target individuals. And for example, Article 5 of the resolution requires that states adopt a variety of measures to prevent the movement of foreign terrorist fighters, including the removal of their citizenship, which is what I'm going to focus on more specifically. So for instance, in November 2014, France adopted a new piece of legislation that includes, among many things, a travel ban for French citizens suspected of terrorism. The UK has a new Counter-Terrorism and Strategy Act 2015. Like every year, it has a new Security and Terrorism Act. This one provides for the seizure of passports of individuals suspected of leaving the UK for terrorist purposes. And in addition, 15 EU member states allow for the revocation of citizenship or of their citizens. This measure usually only applies to people who've obtained the citizenship of the state, and it's only possible for dual citizens because international law prohibits statelessness. Although, interestingly, the new Immigration Act in the UK of 2014 allows the UK government to actually remove citizenship from British nationals even when it would create statelessness in some very specific cases. And so what I want to do is I just want to look at the efficiency of these measures in the broader context of the security situation in Europe and in the Mediterranean. A recent UK report on these measures on citizenship qualified it as ineffective and counterproductive. First of all, there's the condition of dual citizenship, which inherently limits the scope of this measure, because the threat might come from a citizen of the country with no other link to another country. For instance, most of the terrorists responsible for the Paris attack in November were born French and did not have a second citizenship. In this case, the revocation of citizenship is not possible, making the relevance of the measure questionable. In addition to that, there's a strong case law of the European Court of Human Rights, which prevents expulsions to states that are considered to expose people to inhumane treatment or torture. And this means that a convicted terrorist or a terrorist suspect in cases who's been stripped of one of his or her citizenship by one of the states of the Council of Europe might not actually be expelled to his other country of origin and might in effect have to stay in the first state. And finally, in practice, being expelled from one state does not prevent a terrorist from operating, either because they can plan attacks from another country, or because they can still train and recruit other people who might be able to operate in the first country. And in fact, the domestic intelligence, law enforcement, and judiciary of the country of expulsion will not have control over the action of the individuals that they've expelled, which can increase the risk caused by the terrorist, who might enjoy protection or mere laissez-faire in another country, in which case the source of the threat of terrorism is simply moved geographically without actually being stopped. And the question is then, why, if it's not relevant or efficient, do governments still resort to these kind of measures? And the main answer is that these measures are highly symbolic. Terrorism aims to disturb everyday life, and it usually contains a certain amount of theatricality. And responses to terrorism will therefore aim to reassure the population and to show that the government is acting on the threat. For Ben Saul, I quote, "This expresses a deliberate desire by the international community to morally condemn and stigmatize terrorism as an especially egregious crime," unquote. This kind of response, however, means that state might be inclined to adopt a response for the sake of having a response, when often there's existing measures that are sufficiently relevant to address the threat. And this in turn will lead to an inflation of terrorism legislation and a tendency to adopt emergency measures. Gross and Neoland suggest that post-9/11 additions to the criminal law reflect an augmentation of a narrative and memorial style to the criminal law based on the impact of the harm suffered and not an assessment of the capacity of existing law to respond. And this kind of measures can become permanent and change entirely the legal landscape, creating a slippery slope, which itself will create then a climate of fear and resentment towards those suspected of terrorism. And for Daniel Merkley, post-9/11 counterterrorism measures mean the emergence of a shadow of justice that only applies to some. And for him, the result is a distribution of liberties among different categories of people. And the doctrine of enemy criminal law that was developed first in Germany about 30 years ago by Gunther Jacobs is being seen in the counterterrorism policies of today of the EU and the US. And the basis of this doctrine is the idea that some citizens have relinquished their right to citizenship by engaging in acts of terrorism. And the possibility to revoke citizenship allows a state to make a citizen into an alien and transforming them into a them instead of an us. This paradigm is quite obvious in the discourse that we heard from former US President Bush, reminding that you're either with us or with the terrorists. And in addition, it reflects the current situation where there seems to be a discrepancy between the readiness to define attacks from extremist Muslims defined as foreigners or terrorists, and the hesitation to do so for homegrown or white or right-wing action. And in this context, in the wider context, migration expert Elspeth Gilt noted that the 9/11 attacks also, and I quote, transformed the face of the foreigner into a prima facie face of terrorism. And a number of politicians, of European politicians, have claimed that ISIS terrorists are hiding among the refugees. And again, if we go back to Orly, the images of men coming and invading Europe and bringing terrorism to Europe has given rise to nationalistic discourse and claims. And again, if we go back to what Sarah was mentioning this morning, to national policies trying to protect the borders and their national identities rather than transnational action. The Polish Prime Minister said that Poland would not take its share of migrants under an EU plan that was supposed to apply because of the terrorist attacks in Brussels. It is clear that many of the terrorists involved in recent attacks had traveled to Syria and or had established link with ISIS. It is also clear that states have a legal basis for refusing asylum applications where there is a possibility of criminal or terrorist activity, or to expel dual citizens who have been convicted of terrorism. The balance between security need of a country and the human rights of an individual is not a new requirement of international law, and in the EU, including in adopting counterterrorism measures. But the conflation between refugees, between domestic and foreign terrorists, both as others, fueled by the geographical overlap between ISIS and the refugees trying to escape Syria, increases the feeling of us versus them, which does lead to extreme discriminatory regimes, emergency measures, and it tips the balance towards expulsion, rather than encouraging efficient legal measures or looking at the root causes of terrorism or of the refugee crisis. And with the increasing adoption of revocation of citizenship measures and the fear of the refugee, the fear of the other, states return to a geographical attempt to remove the threat. And this increases this dangerous delusion that terrorism can be made into a foreign threat and a foreign problem, diminishing the incentive to deal with it domestically. And this in turn will increase global insecurity and further increase the denial of responsibility of states and of the EU to address this issue. I'm just going to say that these are briefly the issues that I wanted to raise. Again, I'm not suggesting solutions because it is a complex situation, but the conflation and the simplification of narrative, and again, I was struck by Orly's talk about the layering of a problem, is that the simplification of category, the conflation between the terrorist, the foreigner, is just increasing the problem as opposed to trying to solve it at an efficient level. So that's it.